Alright, so the state of Texas has decided to sue the state of Pennsylvania, Michigan, Georgia, and Wisconsin, and
no, this is not the beginning of a joke.
Viva Frei, Montreal litigator turned YouTuber, and I have about an hour to get this vlog done because we have a kid who is home from daycare because he has the sniffles, and we live in a day and age now where you cannot send a kid to daycare with the sniffles. An election lawsuit that is apparently asking for permission to go straight to the Supreme Court of the United States, Texas versus Pennsylvania, Michigan, Georgia, and Wisconsin, and let me tell you something, this is a well-drafted lawsuit. It is an election lawsuit, and the next time someone tells you that there were no voter irregularities anywhere in this election, tell them to read this lawsuit or watch this vlog because they simply don't know what they're talking about or they work for CNN. Ooh, burn. Bada bing, bada boom. Let's get this vlog started. Now, it is an extremely long lawsuit in a sense in that there is a request for permission to file a bill of complaint, and there's an argument brief. We're just going to go over the bill of complaint and highlight the best arguments, the most notable elements of voter irregularities affecting these 4 states. As we will see, it is a well-drafted lawsuit not only in the substance of the allegations, but in the style of the allegations. It is challenging the Supreme Court to take action on the issue. In the Supreme Court of the United States, State of Texas plaintiff versus the Commonwealth of Pennsylvania, the State of Georgia, the State of Michigan, and the State of Wisconsin defendants. Motion for leave to file bill of complaint. In order to go straight to the Supreme Court, you need to ask for permission, hence the motion for leave to file a bill of complaint. Now, I don't know offhand if Texas is going to have the legal standing to file such a complaint. I will be sure to ask Robert Barnes during our next live stream. And incidentally, if you don't follow us on Locals, and while I love ending my vlogs with a noteworthy quote, this lawsuit starts with one of the most noteworthiest of quotes in the context. Quote, "That form of government which is best contrived to secure an impartial and exact execution of the law is the best of republics." End quote, John Adams. Bill of complaint. Our country stands at an important crossroads. Either the Constitution matters and must be followed even when some officials consider it inconvenient or out of date, or it is simply a piece of parchment on display at the National Archives.
We ask the court to choose the former.
And this is what I mean by loving the style. They are starting right off by challenging the Supreme Court to disregard the Constitution. Yeah.
It's a bold strategy, Cotton. Let's see if it pays off for them.
Then we proceed into something of a summary overview of the situation. Lawful elections are at the heart of our constitutional democracy. The public, and indeed the candidates themselves, have a compelling interest in ensuring that the selection of a president, any president, is legitimate. If that trust is lost, the American experiment will founder. A dark cloud hangs over the 2020 presidential election. Here is what we know. Using the COVID-19 pandemic as a justification, government officials in the defendant states of Georgia, Michigan, and Wisconsin, and the Commonwealth of Pennsylvania, collectively defendant states, usurped their legislature's authority and unconstitutionally revised their state's election statutes. They accomplished these statutory revisions through executive fiat or friendly lawsuits, thereby weakening ballot integrity. Finally, these same government officials flooded the defendant states with millions of ballots to be sent through the mails or placed in drop boxes with little or no chain of custody, and at the same time weakened the strongest security measures protecting the integrity of the vote, signature verification, and witness requirements. Unconstitutional revisions to the election statutes, and remember this one, friendly lawsuits.
Raffensperger, I'm looking at you.
This court is the only forum that can delay the deadline for the appointment of presidential electors under 3 U.S.C. Sections 5-7. To safeguard public legitimacy at this unprecedented moment and restore trust in the presidential elections, this court should extend the December 14, 2020 deadline for defendant state certification of presidential electors to allow these investigations to be completed. And then we get into the nature of the action and more drafting that would seem to challenge SCOTUS to not do anything. Nature of the action. Plaintiff state challenges defendant state's administration of the 2020 election under the Electors Clause of Article 2, Section 1, Clause 2, and the 14th Amendment of the U.S. Constitution. And then the challenge to the SCOTUS. As Justice Gorsuch observed recently, quote, "Government is not free to disregard the Constitution in times of crisis. Yet recently, during the COVID pandemic, certain states seem to have ignored those long-settled principles," end quote. Roman Catholic Diocese of Brooklyn, New York versus Cuomo. This case is no different. And if you're unfamiliar with that case, I invite you to watch my vlog wherein I break down that decision because it is a beautiful decision. The lawsuit then describes in general terms the behavioral pattern of the 4 defendant states before getting into specifics per state, which we are going to break down and highlight. Each of defendant states acted in a common pattern. State officials, sometimes through pending litigation, e.g. settling friendly suits, and sometimes unilaterally by executive fiat, announced new rules for the conduct of the 2020 election that were inconsistent with existing state statutes defining what constitutes a lawful vote. Defendant states also failed to segregate ballots in a manner that would permit accurate analysis to determine which ballots were cast in conformity with the legislative set rules and which were not. The rampant lawlessness arising out of defendant states' unconstitutional acts is described in a number of currently pending lawsuits in defendant states or in the public viewing, including dozens of witnesses testifying under oath about the physical blocking and kicking out of Republican poll challengers, videos of poll workers erupting in cheers as poll challengers are removed from vote counting centers, facts for which no independently verified reasonable explanation yet exists. On October 1, 2020, in Pennsylvania, a laptop and several USB drives used to program Pennsylvania's Dominion voting machines were mysteriously stolen from a warehouse in Philadelphia. The lawsuit then goes on to talk about expert analysis, which raises some serious concerns, and this is not a case of throwing everything against the wall in the hope that something sticks. This is pinpoint specific targeting of issues. If this lawsuit survives a challenge on standing, there are going to be some serious questions that the court is going to have to answer. But as far as the expert analysis and the improbability of certain things happening is concerned, let me just read you one highlight. The probability of former Vice President Biden winning the popular vote in the 4 defendant states, Georgia, Michigan, Pennsylvania, and Wisconsin, independently, given President Trump's early lead in those states as of 3 a.m. on November 4, 2020, is less than 1 in a quadrillion, or 1 in 1,000,000,000,000,000,000,000,000. Put simply, there is substantial reason to doubt the voting results in the defendant states. The number of absentee and mail-in ballots that have been handled unconstitutionally in defendant states greatly exceeds the difference between the vote totals of the 2 candidates for president of the United States in each defendant state. In addition to injunctive relief for this election, plaintiff state seeks declaratory relief for all presidential elections in the future. This problem is clearly capable of repetition yet evading review. The integrity of our constitutional democracy requires that states conduct presidential elections in accordance with the rule of law and federal constitutional guarantees. And if you don't render a decision that is in conformity with these constitutional requirements and the Constitution is no longer respected, well then, SCOTUS, it is on you. Do you accept the challenge? Let's get into the specifics. Facts. The use of absentee and mail-in ballots skyrocketed in 2020, not only as a public health response to the COVID-19 pandemic, but also at the urging of mail-in voting's proponents, and most especially executive branch officials in defendant states. According to the Pew Research Center, in the 2020 general election, a record number of votes, about 65 million, were cast via mail compared to 33.5 million mail-in ballots cast in the 2016 general election, an increase of more than 94%. The lawsuit then highlights bipartisan concerns over the security of mail-in ballots, which is a very genius thing to allege. In the wake of the contested 2000 election, the bipartisan Jimmy Carter-James Baker Commission identified absentee ballots as, quote, the largest source of potential voter fraud, end quote. All right, now we're getting into the specifics. I promise, starting with the state of Pennsylvania, or I should say the Commonwealth of Pennsylvania. My apologies. Commonwealth of Pennsylvania. Pennsylvania has 20 electoral votes with a statewide vote tally currently estimated at 3,363,951 for President Trump and 3,445,548 for former Vice President Biden, a margin of 81,597 votes. The number of votes affected by the various constitutional violations exceeds the margin of votes separating the candidates. And what did they do in Pennsylvania? They unilaterally changed the election laws without going through the legislature and made it easier to accept mail-in ballots by abrogating certain requirements as relates to signature verification. Pennsylvania's Secretary of State Kathy Boockvar, without legislative approval, unilaterally abrogated several Pennsylvania statutes requiring signature verification for absentee or mail-in ballots. Pennsylvania's legislature has not ratified these changes, and the legislation did not include a severability clause. On August 7, 2020, the League of Women Voters of Pennsylvania and others filed a complaint against Secretary Boockvar and other local election officials seeking, quote, a declaratory judgment that Pennsylvania existing signature verification procedures for mail-in voting, end quote, were unlawful for a number of reasons. And what did Pennsylvania do?
Settle! Settle, 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 settle!
They settled, and they settled quickly. The Pennsylvania Department of State quickly settled with the plaintiffs, issuing revised guidance on September 11, 2020, stating in relevant part, quote, "The Pennsylvania Election Code does not authorize the County Board of Elections to set aside returned absentee or mail-in ballots based solely on signature analysis by the County Board of Elections," end quote. This guidance is contrary to the Pennsylvania law. First, Pennsylvania Election Code mandates that for all non-disabled and non-military voters, all applications for an absentee or mail-in ballot, quote, "shall be signed by the applicant," end quote. Second, Pennsylvania's voter signature verification requirements are expressly set forth in the Pennsylvania law. For those of you who may not know, in law, when something says shall, it is required. There is no discretion, whereas if it says may, there is some discretion. So when it says shall, you have no choice. You shall do what the law says. But as far as Pennsylvania goes, it gets even worse. The Pennsylvania Department of State's guidance unconstitutionally did away with Pennsylvania's statutory signature verification requirements. Approximately 70% of the requests for absentee ballots were from Democrats and 25% from Republicans. Thus, this unconstitutional abrogation of state election law greatly inured to former Vice President Biden's benefit. In addition, a great number of ballots were received after the statutory deadline and yet were counted by virtue of the fact that Pennsylvania did not segregate all ballots received after 8 p.m. on November 3, 2020. Bookwars claim that only about 10,000 ballots were received after this deadline has no way of being proven, since Pennsylvania broke its promise to the court to segregate ballots and commingled perhaps tens or even hundreds of thousands of illegal late ballots. In the state of Pennsylvania alone, it became apparent that Bookvar did not respect a promise to the court to segregate ballots that came in after a certain date, and now although she warrants it was only 10,000 ballots, there is no way of knowing that. All that is known is that Pennsylvania broke its promise to the court, and if the Supreme Court doesn't do anything, they are just going to go ahead and get away with it. On December 4, 2020, 15 members of the Pennsylvania House of Representatives, led by Representative Francis X. Ryan, issued a report to Congressman Scott Perry, the Ryan Report, stating that, quote, "The general election of 2020 in Pennsylvania was fraught with inconsistencies, documented irregularities, and improprieties associated with mail-in balloting, pre-canvassing, and canvassing that the reliability of the mail-in votes in the Commonwealth of Pennsylvania is impossible to rely upon," end quote. The Ryan Report's findings are startling, including ballots with no mail date. That total is 9,005. Ballots returned on or before the mail date. That total is 58,221. Ballots returned 1 day after mail date. That total is 51,200. These nonsensical numbers alone total 118,426 ballots and exceed Mr. Biden's margin of 81,660 votes over President Trump. And just to finish with Pennsylvania before moving on to Georgia. According to the U.S. Election Assistance Commission's report to Congress, Election Administration and Voting Survey 2016 Comprehensive Report, in 2016, Pennsylvania received 266,208 mail-in ballots. 2,534 of them were rejected. That is less than 1%. However, in 2020, Pennsylvania received more than 10 times the number of mail-in ballots compared to 2016. As explained supra, this much larger volume of mail-in ballots was treated in an unconstitutionally modified manner that included 1. Doing away with the Pennsylvania signature verification requirements. 2. Extending that deadline to 3 days after Election Day and adopting a presumption that even non-postmarked ballots were presumptively timely. And 3. Blocking poll watchers in Philadelphia and Allegheny County in violation of state law. Moving on to Georgia and another lawsuit and another friendly settlement. On March 6, 2020, in Democratic Party of Georgia versus Raffensperger, Georgia's Secretary of State entered a compromise settlement agreement and release with the Democratic Party of Georgia, the settlement, to materially change the statutory requirements for reviewing signatures on absentee ballot envelopes to confirm the voter's identity by making it far more difficult to challenge defective signatures beyond the express mandatory procedures set forth in the Georgia Code. Among other things, before a ballot could be rejected, the settlement required a registrar who found a defective signature to now seek a review by 2 other registrars. And only if a majority of the registrars agreed that the signature was defective could the ballot be rejected, but not before all 3 registrars named were written on the ballot envelope, along with the reason for the rejection. These cumbersome procedures are in direct conflict with Georgia's statutory requirements, as is the settlement's requirement that notice be provided by telephone, not in writing, if a telephone number is available. Finally, the settlement purports to require state election officials to consider issuing guidance and training materials drafted by an expert retained by the Democratic Party of Georgia. Just let that sink in for a moment. The Democratic Party in Georgia sues the state. Raffensperger enters into a settlement agreement that materially changes the elections law and makes it virtually impossible to disregard a ballot for a signature verification. Setting aside the fact that this would obviously, and I mean obviously, benefit the Democrats, how does one go about modifying the law through settlement agreement in a lawsuit filed by a partisan party? Once you fully appreciate that Raffensperger modified decide the substance of the elections law via settlement in a lawsuit, there is no way to go back to looking at this thing normally. That's the best of it for Georgia. Now let's move on to Michigan. Michigan's Secretary of State Jocelyn Benson, without legislative approval, unilaterally abrogated Michigan election statutes related to absentee ballot applications and signature verification. Michigan's legislature has not ratified these changes, and its election laws do not include a severability clause. As amended in 2018, the Michigan Constitution provides all registered voters the right to request and vote by an absentee ballot without giving a reason. On May 19, 2020, however, Secretary Benson announced that her office would send unsolicited absentee voter ballot applications by mail to all 7.7 million registered Michigan voters prior to the primary and general elections. Although her office repeatedly encouraged voters to vote absentee because of the COVID-19 pandemic, it did not ensure that Michigan's election systems and procedures were adequate to ensure the accuracy and legality of the historic flood of mail-in votes. In fact, it did the opposite and did away with precautions designed to deter voter fraud. Secretary Benson also violated Michigan law when she launched a program in June 2020 allowing absentee ballots to be requested online without signature verification as expressly required under Michigan law. The Michigan legislature did not approve or authorize Secretary Benson's unilateral actions. The lawsuit then goes on to allege various violations as relates to the poll watchers, but we've seen this in other lawsuits. How far this goes, who knows? But the lawsuit gets even better towards the end of the Michigan section. Michigan also has strict signature verification requirements for absentee ballots, including that the elections department place a written statement or stamp on each ballot envelope where the voter's signature is placed, indicating that the voter's signature was in fact checked and verified with the signature on file with the state. However, Wayne County made the policy decision to ignore Michigan's statutory signature verification requirements for absentee ballots. Former Vice President Biden received approximately 587,074, or 68% of the votes cast there, compared to President Trump's receiving approximately 264,149, or 30.59% of the total vote. Thus, Mr. Biden materially benefited from these unconstitutional changes to Michigan's election law. That is the best from Michigan. Now let's move on to our final state, Wisconsin. In the 2016 general election, some 146,932 mail-in ballots were returned in Wisconsin out of more than 3 million votes cast. In stark contrast, 1,275,019 mail-in ballots, nearly 900% increase over 2016, were returned in the November 3, 2020 election. Wisconsin statutes guard against fraud in absentee ballots. Quote, voting by absentee ballot is a privilege exercised wholly outside the traditional safeguards of the polling place. The legislature finds that the privilege of voting by absentee ballot must be carefully regulated to prevent the potential for fraud or abuse, end quote. In direct contravention of Wisconsin law leading up to the 2020 general election, the Wisconsin Elections Commission, WEC, and other local officials unconstitutionally modified Wisconsin election laws, each time taking steps that weakened or did away with established security procedures put in place by the Wisconsin legislature to ensure absentee ballot integrity. For example, the WEC undertook a campaign to position hundreds of drop boxes to collect absentee ballots, including the use of unmanned drop boxes. Thus, the unmanned absentee ballot drop-off sites are prohibited by the Wisconsin legislature as they do not comply with Wisconsin law expressly defining, quote, alternate absentee ballot sites, end quote. And as far as Wisconsin goes, it gets even better when it comes to the issue of indefinite confinement. Specifically, registering to vote by absentee ballot requires photo identification except for those who register as, quote, indefinitely confined, end quote, or, quote, hospitalized, end quote. Registering for indefinite confinement requires certifying confinement, quote, because of age, physical illness, or infirmity, or because the voter is disabled for an indefinite period, end quote. Should indefinite confinement cease, the voter must notify the county clerk, who must remove the voter from the indefinite confinement status. Wisconsin election procedure for voting absentee based on indefinite confinement enable the voter to avoid the photo ID requirement and signature requirement. On March 25, 2020, in clear violation of Wisconsin law, Dane County Clerk Scott McDonald and Milwaukee County Clerk George Christensen both issued guidance indicating that all voters should mark themselves as, quote, indefinitely confined, end quote, because of the COVID-19 pandemic. Believing this to be an attempt to circumvent Wisconsin's strict voter ID laws, the Republican Party of Wisconsin petitioned the Wisconsin Supreme Court to intervene. On March 31, 2020, the Wisconsin Supreme Court unanimously confirmed that the clerk's, quote, advice was legally incorrect, end quote. and potentially dangerous because, quote, voters may be misled to exercise their right to vote in ways that are inconsistent with Wisconsin statute, end quote. On May 13, 2020, the administrator of WEC issued a directive to the Wisconsin clerks prohibiting removal of voters from the registry for indefinite confinement status if the voter is no longer indefinitely confined. According to statistics kept by the WEC, nearly 216,000 voters said they were indefinitely confined in the 2020 election, nearly a fourfold increase from the nearly 57,000 voters in 2016. In Dane and Milwaukee counties, more than 68,000 voters said that they were indefinitely confined in 2020, a fourfold increase from the roughly 17,000 indefinitely confined voters in those counties in 2016. So what happened in Wisconsin? Over 216,000 people marked themselves as indefinitely confined such that they no longer needed to abide by the photo ID and signature verification requirements. 216,000 people unlawfully declaring themselves to be indefinitely confined. And now the question is going to be, what is the Supreme Court going to do about it, if anything? And if they do nothing, what impact is that going to have going forward? So that is the story of the time Texas sued Pennsylvania, Michigan, Georgia, and Wisconsin. And now you know the nitty-gritty of the allegations. This is no longer some vague accusations of fraud. They went out and changed the law without doing it properly. In some cases, the defendant states changed the elections law by way of settlement in a lawsuit filed by one of the political parties. If that does not constitute voter irregularities, I don't know what does. And if the Supreme Court of the United States does not think that that constitutes voter irregularities, Lord knows what is going to happen for every future election going forward. To be continued either during a midweek stream with Robert Barnes, or you can find some answers on our locals board, or during our weekly live stream with Robert Barnes. But all that said and done, if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm.
Please, sir, I want some more.
If you want to support the channel, all of these support links are in the pinned comment below. And incidentally, if you're looking for royalty-free music and you go to hooksounds.com and use my promo code, there apparently is an additional 35% discount for the month of December for royalty-free music, and it's good music. But more important than any of that, take care of yourselves, check in on friends and family, have a happy holidays, although I will be seeing you before then, and now you know your vlog. Peace out. Booyah!